Good morning, Your Honour. My name is Dugdale, initials OA, and I'll be appearing on behalf of the Crown. The purpose of my attendance is to request a ruling as to the competence and compellability of the Crown's witnesses and to seek a ruling as to the admissibility of the CCTV evidence, which captured the incident subject to this matter. Before making my submissions, I wish to acknowledge that it's at the Court's discretion as to whether the witnesses are capable of providing evidence and whether the CCTV footage is admissible going forward in this matter. There is no evidence to prove that Sam, whilst a child, is not competent to provide evidence. This therefore means that he is prima facie compellable. Sam is able to provide an intelligible account of the encounter between Adrian, Sarah and Julie due to his close proximity to the event and his understanding of the severity of the matter, with it being reasonable to assume that a child unknowing of the severity of the matter, not moving or not avoiding harm being caused to them by staying in the same area as the assault. The Crown notes that there is no evidence to support the theory that Sam is unknowing of his obligation to tell the truth before the court. As a child under the age of 16 and therefore a special witness, the Crown kindly asks that Adrian and Sarah be removed from the court when Sam is providing evidence, and that Sam's grandmother be present at the time of providing evidence to provide him with emotional support. If the above is not suitable to the court, the Crown kindly requests that Sam be excused from attending at court in person and provide his evidence via video footage to limit further psychological damage being inflicted upon him by having to see his mother and stepfather in the court. Although a husband or wife is competent and compellable to provide evidence for either the prosecution or the defence in any court matter, the Crown acknowledges that a defendant who is a co-accused in a criminal trial is not a competent witness for the prosecution and a compellable witness for the defence. As Adrian and Sarah are co-accused, the Crown acknowledges that it is unlikely that the court will allow Adrian to provide evidence against Sarah in their joint trial. If the court allows the defence to call Adrian to provide evidence, the Crown kindly requests that they be able to cross-examine Adrian. The Crown notes that every person is presumed to be competent to provide evidence in a proceeding. Although Julie has a severe mental disability, there is no evidence to disprove that her ability to use sign language to communicate with the assistance of an interpreter will impact her ability to provide an intelligible account of the assault by Adrian and Sarah, with the interests of justice impeded if an interpreter is not provided. Likewise, there is no evidence to suggest that Julie is unknowing of her obligation to tell the truth before the court. The Crown acknowledges that Julie may not be considered competent in circumstances where she is unable to answer elementary questions before the court, or if her mental impairments are considered such that she is not deemed competent. The footage captured by the CCTV camera, hereby referred to as the footage, provides direct evidence of the assault of the complainant by the co-accused and would directly assist the Crown to satisfy the necessary elements, that is, the identification of the co-accused, causation of the complainant's injuries by the co-accused actions, and the necessary elements in convicting the co-accused of committing grievous bodily harm against the complainant. The Crown acknowledges that the footage, in the form of a film, is considered a document pursuant to Schedule 3 of the Queensland Evidence Act. In no opinion or argument could the footage be considered to have no rational bearing upon the conviction of the co-accused. The Crown considers the footage to not be considered inadmissible as it is not prejudicial to the co-accused defences by way of damaging their prospects of a fair trial. The Crown considers the footage to provide the fullest and most accurate depiction of what occurred that night due to its inability to be influenced or changed from its original form. The Crown does acknowledge the possibility of the footage being inadmissible as a result of it being obtained legally without a search warrant, but asks the court to consider the gravity of the accused actions, being that of bashing a mentally impaired girl who was a child of one of the co-accused with an object causing grievous bodily harm, in comparison to the officers not obtaining a search warrant to collect the video footage before making their determination. The Crown references the case of Aberdeen, in which the conduct of the police in obtaining the evidence was weighted against the public's interest to suppress the crime committed. The Crown also considers the circumstance of the attending police officer's obligation to gather evidence in pressing circumstances, with there being a real possibility that the footage could have been destroyed by the accused if left in the house for too long. The Crown thanks the Court for its time and wishes to be excused.